The next matter to come before the court this morning is 22 Exchange LLC versus Exchange Street Associates LLC et al. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. I note that we have more than one counsel for the appellant. If you just split that time, that's fine. Just let me know so I'm keeping everyone apprised of the time. Also, if you'd like to reserve some time for rebuttal, let me know, so I will keep you apprised of that as well. We've read the briefs and are ready to proceed when you are.
I'll be doing the entire argument. I'd like to split my time, 10 minutes and 5 minutes. Would it be possible to get a 3-minute warning on my 10 minutes, Your Honor?
Sure.
Thank you very much.
Don't make me do the math up here.
No,
I didn't mean, it's fine.
Okay. I'm ready to proceed, Your Honor.
Thank you.
May it please the Court. Your Honor, I'm Bobby Pryor, and along with Chris Swing, we represent the appellant in this matter, 22 Exchange. And we're appealing 2 orders from the court below. A February 5th order, which dismissed our fraud claim, and a May 14th order, which denied our request to amend our complaint. We stated a claim for fraudulent inducement in our amended complaint. And the elements of that are set forth in the ABM Farms case, a material misrepresentation, or concealment, which we relied upon. We allege all those facts. We allege facts of concealment regarding iPad use to accelerate the leasing, and which increased the value of the building. A water leak problem, which is quite severe, which was actively deceived and concealed from us. They instructed their property manager not to tell us about it. They did cosmetic work to cover it up from us. And they also gave us a velocity report, which misrepresented when certain leases were entered into, and velocity of the leasing impacted the price. These were misrepresentations or concealments of present facts, and that's significant in regard to whether or not these would be barred by the integration clause in the contract. Now, we styled this case in our amended complaint as a fraud claim. We didn't use the word inducement. In fact, in the ABM Farms case where they set forth the elements don't use the word inducement either. But in any event, when we argued this to the court, we argued it as inducement. And we, in our reply brief, we talk about the Galmish case. We talk about how we were fraudulently induced into entering into this contract. But we did not style the case as fraudulent inducement in our pleading, and we've cited the court, the Franco case and the Punt case from the Ohio Supreme Court, which says you look to the substance of the allegations, not the headings. And nonetheless, the trial court interpreted this as a simple fraud case. And if you look at her February 15th order, she relies upon the Textron case and this court's opinion in Terraquinio. And both of those cases are fraud cases alongside a breach of contract. Both of them involve fraud that occurred after the contract was entered into. And she said that our claims were subsumed by the contract, applying that rationale. The allegations that we're complaining of occurred before the contract was entered into and induced us to enter into the contract. She says we have no separate damages. Well, you don't have to prove separate damages when you have an independent claim such as fraudulent inducement. But in any event, we have rescission damages which were not available to us under the breach contract. We pled those. They're in our prayer for relief. She says that we did not establish an independent duty and did not plead it. If you look at paragraph 47 of our amended complaint, we complain that they concealed facts from us and they had a duty to reveal them to us. The King case, which we cite to this court, says the common law duty not to deceive a party into entering the contract or agreement is independent and separate from a duty not to breach a contractual obligation. So there was a separate duty to not fraud us and induce us to enter into the contract. Now, those were the only basis that she had for denying for dismissing our fraud claim. There are other issues that have been raised by the defendants, and they were raised in the May 14th order. One of them is the parole evidence rule and whether or not the integration clauses apply here. And in a fraudulent inducement case of present or past facts or concealment, the parole evidence rule does not apply. The Watkins case, just to read their language, fraud in the inducement in the sense intended in Coal Resources and Galmish is a fraudulent misstatement of fact that induces a party to enter a contract, not a fraudulent promise of future performance. If you look at their cases where they're saying that our claim is barred by their integration clause, those are future performance cases or cases that directly contradict the contract. The Coal Resources case, Sixth Circuit case, the dissenting opinion correctly states that an integration clause does not bar a party from demonstrating fraud in the inducement. This point is irrelevant, however, because this case does not involve a fraud in the inducement. Gulf and Western's promise to invest $3.9 million was a promise of future performance rather than a representation of past or present material fact. If it's past or present material fact, it's not barred by the integration clause or by the parole evidence rule. The Niehaus case, we have numerous cases for this. There's an Ohio Supreme Court case, the Galmish case, which discusses this, and it flatly says fraud cannot be merged. And they're saying, and they discuss in great detail, that we don't care what your integration clause says. If you fraudulently induce someone to enter into that contract, you can't point to an integration clause to save yourself under the parole evidence. Fraud does not merge. Thus, the presence of an integration provision does not vitiate the principle that parole evidence is admissible to prove fraud. Now, the Galmish case was a case where the party entering into the contract never intended to perform, and that was the fraudulent inducement that the court found. There are two types. One is a misrepresentation that's material of present fact. The other is that you never really even intend to perform. They try and distinguish Galmish because it deals with the latter, but the holding of the court is still applicable. They argue about the statute of frauds. If you look at the footnote in Galmish and in other cases, it says that the analysis is the same as with the parole evidence. There's nothing about the statute of frauds that allows them to commit fraud on us, to induce us to enter into contract, and then try and hide behind the statute of frauds. The two cases they cite, Marion and Olympic, deal with future performance or contradiction of the contract. They argue that they have an as-is clause, and that when we took that property as is, then the fact that a water leak showed up, too bad. Well, except for the fact that we allege they knew about it and they actively concealed it from us. This court in Tipton says, while an as-is contract bars a claim for non-disclosure, it does not bar a claim for positive fraud, such as fraudulent concealment or misrepresentation.
Council, 8 total minutes remaining. 8 total minutes.
Thank you. I've already used 8 minutes. Okay, very quickly on the May 15th order. We realized the court viewed this as a fraud claim instead of a fraudulent inducement claim. We asked the court for leave to amend to now call it a fraudulent inducement claim. And we had discovered additional facts, and we wanted to plead those additional facts. And the court said no. And here's her reasoning on this. She says that, well, gee, you've already pled all those facts, and you could have alleged this claim before. That makes our point, Your Honor, in terms of she is elevating form over substance. We allege the substance in the complaint. She should not have dismissed it. She says that she admits there's no case management at the time this occurred, but she says this case has taken a long time. Let me address a few things on that. We filed our motion to amend before all the parties had even entered into the case. There was no case management. After the case management order, they filed a counterclaim which raises tort issues that arise out of our tort claim that was dismissed. That's going to have to be dealt with in a new case management order. And there's no additional harm to this case from a case management standpoint. We filed this case on August 5th, and they then removed, of last year, they then removed this case to federal court. And that did delay things. And the case was remanded. They were in fact sanctioned. They had no basis for removing to federal court. When they moved it back down, they immediately filed a motion for judgment on the pleadings. That was filed in October. The court didn't rule on that until February 5th. We then, as soon as the court ruled on that, she denied their effort to dismiss the contract claim. We set about correcting the fraudulent inducement issue and timely filed our motion. She didn't rule on that until May. So the case has taken some time, but it's certainly not been at our fault. We've been diligent. The cases that we cite involve much more time than that. There's been no finding of bad faith. The court didn't say we did anything in bad faith. There's no evidence of prejudice. They don't put on any evidence of their prejudice. The court said, well, she came up with some prejudice for them. She said, well, they might have to file another motion. We cite the Jordan case to this court that says the fact that they might file another motion to dismiss is not a basis for not allowing an amendment. They cite two cases to the court in additional authority, the Rose case and the Bear case. The Rose case involved a period of years with a pro se plaintiff. It's nothing like our case. It was involving after a summary judgment motion, not a before discovery. By the way, very little discovery in this case, not one deposition. And it was also a Rule 15E case. The Bear case, the same situation, except it was over even a longer period of time.
And Counsel, you're reaching into that 5-minute rebuttal time.
Thank you, Your Honor. I reserve my time.
Thank you.
Good morning, Your Honors. I'm Mike Stavnicki. I represent the appellee, the defendants, the sellers. It happened during the underlying case, and it happened again today. I cannot shake the phrase, when I listen to their arguments, when I read their briefs, that they're grasping at straws. That they're like a drowning man who's going down the river, and you're grasping for anything you can to hold on to your claim. They don't want to get their claim swept away and go under. How do we know that they're grasping at straws? Because when they initially brought their claim in August of 2013, they didn't bring a fraud claim, they didn't bring a negligence claim, no tort claim of any kind. They brought a one-count breach of contract action. Now the contract in this case, which the court may have seen in the file, is massive. It's the size of a phone book. It's had 8 amendments. There were years of due diligence. It was signed, I believe, in February of 2012, so over 3 years ago. They brought one claim for breach of contract, and what they brought was a claim that said the defendants, the appellees, have breached the contract because you didn't give us accurate floor plan lease dates, and that term becomes important.
Floor plan what?
Floor plan lease dates. The sale of the building at issue here was a student housing complex. It's located at 22 Exchange, so it's a lot of college students. And what a floor plan lease date is the date that a student signs a lease for the type of floor plan. It's different than the final lease because the final lease is the actual binding lease. The floor plan lease is, will you be in a 2-unit, will you be in a 4-unit? They brought a breach of contract claim based on one term, floor plan lease. Here's the problem. Nowhere within the hundreds of pages of that contract, nowhere in the 8 amendments to that contract is the term floor plan lease ever used. As soon as we got the complaint, we moved for judgment on the pleadings. And we said, you're claiming the breach of a term, but that term is not part of the contract. As soon as they got that, you could feel the audible gasp from Texas. They didn't know what they entered into. They didn't know the terms of their own contract. They either misread it or not read it. So all of a sudden, it was a simple breach of contract claim. One count based upon you didn't give us accurate floor plan leases turned into something new. They had to do something to salvage their claim. So what happened? We moved for judgment on the pleadings, saying you're claiming a term that's not in the contract, they immediately move to amend. So now, the breach of contract of this 200-odd page agreement with 8 amendments that have years of due diligence, now it's not a breach of contract because their breach of contract claim will lose. Now, it's a fraud. What do we do when they bring their fraud and their tort claims? We look at Ohio law, we look at the terms of the contract, we look at the nature of the claim. They don't realize their claims are barred again. Because as this court knows from the Textron case, from the Gallamish case, it is the true nature of the claim that controls. This claim involves a, again, 100-page, 100-plus page contract. It's a contract claim. But they know they can't survive with their contract claim because they don't understand the terms of the contract. Because the term floor plan lease is in it. Now they spin it. They grasp at straws and are like, well, we're going to lose on our contract claim, so we'll make it something different. We'll claim it's fraud. The trial court allows them to amend the first time. We then oppose their amendment. We argue to the trial court and explain to them it's not a tort to breach a contract. Just because your claim is going to fail, you cannot change the true nature of the claim. A tiger can't change its stripes. This is a contract dispute. If we've done something wrong, which we haven't, if we didn't give floor plan lease dates, which that term is not in the contract, it'll be a breach of contract claim. If there's a construction defect, it's governed by the contract. If there's some representation, some breach of a clause in the contract, it's a contract claim. The problem is they realize that that claim is going to lose. So they spin it, and they turn it into fraud. But they ignore Ohio law. They ignore the Textron case, the Gallamish case, American Seaweed. All of these cases say it's not a tort to breach a contract. And they also say, and I don't think they get this, I wouldn't call it a nuance, fraud is fraud is fraud. They keep trying to spin it and say, well, if it's not misrepresentation, then it's a concealment, and then it's an inducement. Fraud is fraud. If you look at any of the cases anybody cites, you can just interchange the word concealment or misrepresentation or inducement into the elements. The elements remain the same. The problem is when you have a contract that governs the terms, that governs the framework of the transaction, which we clearly have here, everyone has to admit it, it's how the claim started. You can't allege fraud. You cannot allege fraud unless it's one of two things. This is what the Ohio Supreme Court told us in Gallamish. The fraud has to be completely outside the contract, or the fraud has to be completely consistent with the contract. None of those things have been alleged here. For fraud to be completely outside the scope of the contract, the best analogy I can come up with is if there were 2 buildings. So we were entered into a contract to sell them 22 Exchange, but we also owned a building across the street. And we said, we'll enter into a contract for 22 Exchange, but we know they want to buy up more buildings around it. So what we tell them is, we'll enter into this contract, but you want to buy that other building too? Yes, we do. And we'll sell it to you on the same terms, but first let's deal with contract number 1. So we fraudulently induce them to enter into number 1 because they think they're getting the whole city block. They think they're going to get the building next door. That might arguably set forth a claim for fraudulent inducement.
But what about his claim that it's more like the exterminator comes in and says, yeah, your house is full of termites and they're going to exterminate the termites. They actually come in and do the extermination, but there was never any termites there to begin with.
Well, again, that's analogous to something completely outside the scope. And the funny thing is, I looked at that, and I'll address that, Your Honor. That's the Wall case. And the funny thing is, when you look at that case, it's actually a car case. And what the court, I think it's the first district, what the court said in that case was, here's an analogy of an example that we could think of for fraudulent inducement, but that actually wasn't the fact of that case. In that case, they struck down the fraud claim, which related to like a home loan that was going to be used to finance her car, and they said there's no representation as to the home loan. The problem we run into here is that they run into, not that we run into, is the contract itself. In this contract, let's deal with the 3 aspects of fraud that they're claiming. They're saying leasing, okay? Number 2, they're saying construction defects, a water line. Number 3 is iPads, marketing. Unlike the termite example, where the person just comes in and says, they told you something else behind the scenes, and then they say, well, for $200 I'll do the termite infestation spray. There's no representation that it was or wasn't infested in that agreement. So it's outside the contract. Here, all of those things are in the contract. Nobody's claiming that we were trying to sell them a building other than 22 Exchange. No one can claim that the construction aspect, the physical condition of the building was not part of the transaction. There is a 2.5-page capitalized, different font disclaimer in the agreement, which says, if the representation is, this is not just an integration issue, this is not just a simplistic parole evidence issue, we would win on all of those as well. It's the disclaimer that's the key. It says, we are making no representations as to the physical condition of the building, as to valuation, as to projections, as to historical finances for the building. It's set forth in this giant font for 2.5 pages. They can't claim fraud, and they can't claim justifiable reliance on something when they're told, we're not saying this. It's the complete kind of antithesis of the analogy in that Wall case. We actually say the opposite. It's not, we say, don't rely upon anything we tell you with regards to the condition of the building. You will rely upon your own due diligence, that's what it says, investigation and inspection. That's the part they don't get. They're trying to cobble together fraud. They're trying to kind of end around the contract. The contract is bad for them. But the problem is all of their claims directly conflict with the contract. If they're claiming a water leak, but the contract says, we make no representation, it's not just an as-is, we make no representation as to the condition of the building. If you've heard anything from us with regard to the condition of the building, you are not to rely upon it, and in fact, they represent it back to us. You will rely upon solely your own independent investigation and inspection, and we are providing you the right to inspect it. You can never show justifiable reliance when you've had the right to inspect. You can never show justifiable reliance on a representation when we tell you don't rely upon this. How is that ever justified? We've told you don't believe anything you've heard or anyone you've talked to. If it's not within the 4 square corners of this contract, it doesn't exist. That is the cardinal problem with their claim. It's not something outside the contract. The leasing is represented in the contract. They attached a rent roll. The occupancy is referenced in the contract. We attach this Exhibit 8, this velocity report. The construction is represented in the contract and is specifically disclaimed. I think the case that's the most analogous that we cited to is probably the American Seaway case. I think it's an 8th District case. And it was the sale of a business, it was a grocery store. And the buyer said, well, you defrauded me. You gave me financial information, analogous to this case, about the company. But that was all false. And the court looked at it and said, you can't claim fraudulent inducement with these claims because these were specifically disclaimed. You can't be induced by something that was expressly disclaimed. That flies in the face of the law. It flies in the face of the parole evidence rule. It flies in the face of integration. More importantly, maybe not more importantly, but equally importantly, it flies in the face of common sense. If someone tells you, you're taking this just as it is, with all faults, you go inspect it out the wazoo, you rely upon what you can find. You can never be justified relying upon anything else. You've had the full capacity to go through it. They've audited the leases. There's nothing wrong with the leases. They just have buyer's remorse. They don't want the building for whatever reason, and they're trying to get it back. The problem is the contract bars all of their claims. Again, this, I think it's of significance. They cite to some cases where they talk about as-is clauses and home sales. I mean, there's an as-is clause in this contract. That's not really the issue. The issue in this case is this is a $28 million commercial sale between sophisticated parties with 2 years of due diligence, with 8 amendments to a contract. The arguments that they're making would tell you to just ignore the contract. It doesn't matter. It's just fraud. Why did we spend 2 years negotiating the contract? Why did they go through 8 amendments, or their predecessor go through 8 amendments?
I understand that at the trial court level, your clients were maintaining during the proceedings regarding certifying this for Civil Rule 54B language so that it could come up in an appeal, that you were arguing it was not a final appealable order. Is the argument still the same, or are your clients concede that, or agree that because the language was added, the Rule 54B language was added, that this is a final appealable order and we have jurisdiction there?
Yeah, I mean, we have ever talked to my clients expressly about that, whether they agree or they don't agree. I have not, that I can recall. If I did, it would have been in the summer. Again, because there were still pending claims, me as the lawyer from a legal standpoint, I thought that it wasn't final appealable because the case was still active, because there was still a breach claim. Again, the court found, and I think probably properly so, that we got to come up on these claims because it's a large set of their claims. So again, did I ever talk to my client about waiver of the certification? I have not. Do I believe the court, did I understand and legally agree with the court's logic for certifying? I did, because it's the bulk of the claims that were thrown out by the court. Real quickly, touching on something that Mr. Pryor said, that's another problem with their claim that they don't understand with the contract is for a tort claim to exist. Again, the tort claim has to be consistent or completely outside the contract. None of those issues exist here. There also has to be a duty separate from the contract and damages separate from the contract to have a fraud claim. Okay, well, first of all, we've shown that everything with regard to this transaction is within the scope of this contract. Years of due diligence, 8 amendments, hundreds of pages. I mean, every possible scenario and condition is related is referenced in there, from marketing to construction to environmental to the status of the building to the fact that my client owns a competing business nearby. So everything was governed there. But what is the duty? If my client didn't enter into an agreement with them to sell them the building, what is the duty that they owe to them? There's no separate duty. It's the true nature of the claim that governs. This is a contract claim. Without the contract, there's no duty, because these people aren't in business with each other. What is the damage that is flowing from this fraud claim that can't exist if you don't buy the building, which relates to the contract? You have no damage.
And counsel, you've reached the end of your allotted 15-minute time. Thank you.
Thank you, Your Honor. We would ask that the case be affirmed. The decision be affirmed.
Your Honor, counsel is arguing there's no such thing as fraudulent inducement when there's an integration clause. That's not the law in any state. It's certainly not the law in Ohio. He says the best case for them is the American Seaways case. Let me tell you what they say in their brief on pages 11 and 12. In American, the purchaser of a business claimed that the seller had made fraudulent misrepresentations regarding the financial success of the grocery store. The purchaser claimed that the seller had provided false financial forecasts, future performance, what's going to happen in the future, not a misrepresentation of present fact. That's why in that case they did not apply they said it would be barred by the parole evidence rule. The misrepresentations to us were present fact. The Coal Resources case, the 2-6 Circuit case, the Galmish case, these cases all stand for the proposition you cannot fraud someone into a contract and try and cover it up with a merger clause. Now he says that this is a construction defect regarding the water leak. Well, what they did was a concealment. They concealed it from us. And we're not saying the construction defect's the issue. The issue is the concealment of it, so we couldn't evaluate it and make that part of the price. The iPads, they, in their brief, talk about, well, we have this exhibit that talks about we're going to do marketing. Counsel seems to think that anything that relates to the contract, that therefore it doesn't matter if we lied to you about it and covered it up. That's not the case. Unless we're specifically contradicting the contract, if it's a material misrepresentation or concealment, it's fraudulent inducement. The marketing effort says they can do marketing. What they did with the iPads is they didn't tell us about it, that they did, and they covered it up. They didn't even put it on the books of the record. They used their personal Visa cards to pay for the iPads so that we wouldn't find out they had done it. So this is active fraud. This is not buyer's remorse. This is millions of dollars in damages regarding the water leaks and an overinflated price because of the false velocity report. By the way, that's the distinction between our velocity report and the American Seaways case. That was a forecast. Telling somebody what you think is going to happen in the future regarding the performance of the contract is probably going to get merged into the contract. A false statement, intentional knowing of present fact, that's fraudulent inducement, certainly concealing it. Now, counsel says that this is all because we're worried about our breach of contract claim. The court denied his motion for judgment on the pleadings on the breach of contract claim. We're not concerned about that. They argue we don't have standing. If you look at the contracts, we are the parties to this contract. We pled that, and the lower court found that. They've not appealed that ruling. We do believe, Judge Shaver, that this is more like the wall example of the termite. What they're arguing to this court is they can know there's a serious leak problem. They can put paneling up to cover up the evidence of it. They can then have us sign a contract saying, oh, it's as is, and there's a merger clause. And too bad. You didn't discover it. You should have found it out. That's not the law. As the Galmish case says, the Ohio Supreme Court case is consistent with every other state. You cannot merge fraud. Now, had they put in the contract, by the way, we've been lying to you about this, and there's this horrible water leak problem, and we're telling you about it here in the contract. Okay, there you go. They didn't do that. The lower court, I want to emphasize, if you look at our pleading, we've pled all the elements of fraudulent inducement. She never analyzed it as fraudulent inducement. She analyzed it as being subsumed by the contract. Counsel says, where's the independent duty? There's a common law duty in Ohio and every other state not to intentionally deceive someone, to get them to enter into a contract. We cite the King case with that, but there are many others. The court did not do that analysis. At best, the court looked at our pleading and it said fraud. And a death penalty for my client's significant claims, because we use the word fraud instead of fraudulent inducement, is definitely form over substance, and counsel says all fraud's fraud. Well, there's certainly that argument. In footnote 4 of our brief, we cite a dozen cases that relate to that issue. So we believe that it's a de novo review, that our fraudulent inducement claim was stated in the First Amendment complaint, and that we should be allowed to amend. There's been no showing of prejudice. They don't argue prejudice.
And counsel, you also reached the end of your allotted time. Thank you both for your presentations this morning. The court will take the matter under advisement and issue a written decision, which will be mailed to both sides, as well as posted on our website and the Supreme Court website. Thank you.